नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
Speak. Okay, fine. Because sometimes I don't know, in Google Meet once or twice I've lost my mic. I don't know if it's my computer problem or the. Okay. Now look. Let's now look. Today what I plan to do is I'm going to repeat just a part of the Lok Prahari and the judgment of consumer education research study, and then I'm going to go on to discussing the articles 85 and 174 and looking at in re the presidential reference of 2002 dealing with the Gujarat elections. Monday, I'm going to take up the all-important topic of defection, the 10th schedule, and Raja Rampal. I'll probably need one class or two classes for that. I'm keeping the entire weekend. I would expect everybody to read the following things. One is Article 102, Subclause 2, which is disqualification by the chairperson of the Rajya Sabha, Speaker of the House. That's number one. I expect everybody to read the 10th schedule, all the paragraphs fully. If you have time, you will read Quixote Holohan versus Zachilho, which is the very important constitutional law case of 1992 by Judge Bench, if you have time. But I want everybody definitely to read Raja Rampal, which is in the case material dealing with disqualification. This is the money for questions scam and the disqualification. Okay, there are of course a large number of cases relating to disqualification. Most recent is Mr. Sachin Pilot in Rajasthan. But before that, we have the Pondicherry case, the disqualification of MLAs. We have the Tamil Nadu case, disqualification of MLAs. We have at least two cases from Karnataka, disqualification. Then we have cases from Nagaland, other places also. I'm going to concentrate on Raja Rampal, which will explain to us the law on the point. And I will be teaching Quixote Holohan versus Zachilho. If any of you have time to read it, read it. Okay. So the entire defection I'm going to take up on Monday because I want the class to be well prepared for this. Okay, you know that it's politically a very interesting issue. It's politically also a very significant issue. And how do we deal with dissent within the party? How do we deal with defections within the party? How do we, any party, and how do we deal with breakup of parties and whether parliament should be concerned with inner party democracy or not? So there are deeper philosophical questions, deeper than just the legal questions. What concern is it of parliament about how a political party conducts its internal affairs? Should we be bothered or not? So then there are the deeper political philosophical questions which are completely relevant when we are looking at the legal interpretation. So all that for Monday. Please spend your time over the weekend and read it. Now let's come back once again to the question of disqualification by the president. Just to reiterate what we've done, I'm not going to spend too much time. We've spent a lot of time. I want you quickly to look at 101, 102, 103 and 104 so that we are all clear constitutional provisions. Let me begin with that provision which I have not discussed in class ever, which is Article 104. Penalty for sitting and voting before making oath or affirmation under Article 99. When a person gets elected, he or she is expected to take the oath and then only sit or vote. It's a very unusual provision, I can tell you, because technically speaking, there is no way in which somebody could just come and sit in that place without taking the oath. But if that happens, please look at this. If a person sits or votes as a member of either House of Parliament before he has completed the requirements of Article 99, Okay, and look at 99. Every member shall, before taking, make and subscribe before the president, or that he is prohibited from doing so by some provision of any law made by Parliament. Suppose a person has switched his citizenship, or he has been declared of unsound mind by a competent court, whatever it is, then he is prohibited from doing so. Then he shall be liable in respect of each day on which he so sits and votes to a penalty of 500 rupees to be recoverable as a debt due to the union. It has not made it an offence, but it has created a penalty. It's not a provision flowing to us from any criminal statute, but it is a penalty and it is a fine. It's not even a fine, it's actually a penalty, and which will flow. Now, for sitting and voting for violation of 104, is there a disqualification from membership? That is, without taking an oath, if you sit, you don't get disqualified. You only make the penalty. The other two limbs, you're already disqualified, but still knowingly you and intentionally you sit in Parliament or the Legislative Assembly. You will then pay the you are in any case disqualified. Okay. So it doesn't really matter. Or he is prohibited from doing so by the provision of any law made by Parliament. Parliament has made these rules that if a person is absent without permission for 60 days, then the House should be told, and then the House can resolve to remove that and disqualify that person, and the vacancy will arise. So that's 104. 103 we've already looked at yesterday and day before, which is that if there's a question of disqualification, then opinion of election commission. Now 102, and I look now particularly at 102 subclause 3 subclause A. If a member of either House of Parliament becomes subject to any of the disqualification, those of you who have taken the care to read the Consumer Education Research Society case carefully will know that because of the language, not became subject but becomes subject. Look at the English language. It is in the present continuous, and the Supreme Court says becomes subject to any of the disqualification means that the disqualification arose after he became a member of the House and took the oath. If it is after you've become a member and taken the oath, then the disqualification will be done by the president. And what does Consumer Education Research Society tell us? It tells us that if the disqualification, and it could be any of them, it could be the Office of Profit 1, unsoundness of mind, etc., which is laid out already for us in 101, in 102, then what 102 tells us, 101 tells us is that these disqualifications, 101 read with 102, it is the president who determines, or it is the chairperson or the speaker who decides. In which case, Consumer Education Research Society clarifies to us that the disqualification will not be on the date that he became unsound of mind or on the date that he took up an office of profit, but it will be on the date that the president issues the order. I explained the reason why yesterday, and the court, those of you who read the judgment will see that because once it is disqualified, then there is only a 6-month window for the election commission to fill up that seat. And therefore, the actual order passed by the president or by the chairperson or by the speaker becomes crucial. Then, now I come to 101 subclause 4. Look at
excuse ma'am.
Yeah.
Yes. Ma'am, could you please just once again repeat From what day the disqualification would be?
From the date that the president issues his decision under 103 subclause 1. It will be from the date that the chairperson of Rajya Sabha or the speaker of the Lok Sabha issues the order disqualifying this member for defection from that date. So the defection could have happened 6 months earlier. He may have left the party, he may have disobeyed the election whip, he may have defected to another party, whatever. I'll come to that on Monday. But that may have happened like few months earlier. But the disqualification will take place only on the date that the chairperson of the Rajya Sabha or Lok Sabha, Speaker Lok Sabha, issues the order. That's what Consumer Education Research Society clarifies. So now I've looked at two provisions. President disqualifying for office of profit. This office of profit, she or he must have joined after becoming a member of the Lok Sabha. I have not yet come to what happens if they had become members of Office of Profit, which had disqualified them from even contesting for the election under the provisions of the Representation of People's Act. That I'll come to later. But let's look at the other categories. Look at 101 subclause 4. I'm on 101 subclause 4. Oh, I'm sorry, I'm trying to type with the one hand. 1 minute. Look at 101 here. If for a period of 60 days a member of either House of Parliament is without permission of the House absent from all meetings thereof, the House may declare his seat vacant. So when does this vacancy happen? On the date that the House, through a resolution, decides that it is vacant. Then a person also can resign from the House. The date of vacancy will be on the date that the Speaker or the Chairperson, depending on whether it's Lok Sabha or Rajya Sabha, accepts that resignation. It will take effect from that date. All these, so the dates are different for all the categories. And now let me come to the category which is dealt with in Lily Thomas as well as in Lok Prahari. Okay? And before I'm going to ask Anjali to just give us the quick facts of Lok Prahari and then to explain, and I'm going to put questions to Anjali so that it's clearer to all of you, what was clarified in Lok Prahari vis-a-vis the Lily Thomas 5-judge bench decision. For those of you who have not, please read the Justice Patnaik's judgment, unanimous judgment for the 5-judge bench in Lily Thomas 2013, and then read, there are 3-4 Lok Praharis if you searched on Indian Kanun. Choose the 2018 one, judgment written by Justice Chandrachud. We are on that particular Lok Prahari. Anjali, are you present today?
Yes, ma'am, I am present.
Yes, Anjali, please explain.
Ma'am, the title of this case is that Lok Prahari versus Election Commission of India and other parties Union of India. And this is a 3-judge bench, CBI Justice Deepak Mishra, Justice A.M. Khanwilkar and Justice D.Y. Chandrachud. And the judgment has been written by D.Y. Chandrachud. So, ma'am, I just want to take some background of before that case was filed. Before that, ma'am, many cases were filed against MLAs and MPs, and after that, many petitions have been filed in Supreme Court. So, Supreme Court in many various judgments had given the order to clarify their assets and criminal liability and criminal convictions before they are contesting election. So, ma'am, fact of this case is that Lok Prahari basically is an NGO, and this is a PIL by PIL in the Supreme Court. Then what happened in the case is that one MLA from the UP was convicted under many various provisions of IPC. IPC section 353, 354, 504 and 506 of IPC. Ma'am, these provisions are basically prohibiting the person from discharging their public duties and the punishment of these offenses is 2 years. So, ma'am, they attract 2 years punishment attract RP Representative People Act Section 8 Clause 2. Ma'am, that means if a person who is convicted by the court for 2 years, he will be disqualified. If he is contesting also, and if he is a member, also disqualified by the disqualified being a member of the house. Ma'am, and after that, this Lok Prahari filed an appeal in the High Court of Allahabad, Lucknow bench, and Lucknow bench dismissed this petition. So, ma'am, after that, they filed a writ petition under Article 32 of the Constitution. Ma'am, I have doubt from this that I think through Article 14 they have violated, so that they go through Article 32 of the. Am I right, ma'am? So, ma'am, so they go to Article 32 of the Indian Constitution, the Supreme Court of India, so to clarify whether the person who ma'am, basically in this case, this MLA was convicted by district court, but ma'am, he goes to appeal, and under Section 389 of the CRPC, the terminology was that stay on conviction. Now, stay on conviction meaning is that stay on conviction means the person is innocent.
Okay, now what I want you to do, Anjali, please explain to us what is the distinction between stay on execution of the sentence and stay on conviction. Please explain this distinction.
Ma'am, stay on conviction means is that the charges against any person is stay on conviction means person is innocent, but stay on execution of conviction means person is not innocent. Their punishment has been their punishment is मतलब उनकी punishment हो चुकी है मैम, और that punishment execution में उनको रोक लगाई है. Stay on execution, but they are not innocent person. So that you gave example that pregnant lady. Ma'am, if a lady is pregnant, so how can we execute the conviction? So the power of the court is that they can extend the conviction that the person is not innocent.
That's right. So the stay of the conviction means that the culpability of the accused for temporarily has not been fully taken away but is suspended till the appeal is decided. Therefore, because the conviction gets suspended, the disqualification which was there under Section 8, Subclause 3 of the Representation of People's Act will no longer be applicable. However, if there is a stay on the execution of a sentence, meaning on the person actually performing the punishment, the person being imprisoned as required by the lower court, that punishment gets postponed, there is a respite, but the punishment and the conviction still continues to operate. And because the conviction still continues to operate, if the conviction is for a period of more than 2 years, if it is a case under subclause 3 of section 8, or if it is a conviction under one of the provisions under subclause 1 of section 8 of the Representation of People's Act, the disqualification to contest the elections continue. And therefore, in the B.R. Kapoor case, there had been a stay only of execution of sentence. But in this particular Lok Prahari case, there was a stay on conviction. And therefore, what did Justice Chandrachud say on behalf of the 3-judge bench? Anjali.
Ma'am, Justice Chandrachud says that, ma'am, should I go directly to judgment?
Yes. We don't have too much time. In another 2 minutes, you must summarize what the decision of the Supreme Court was.
Ma'am, the Supreme Court decision was that, ma'am, the higher court can exercise their right to stay on conviction, but ma'am, because there are many frivolous and fake cases against MPs and MLAs, so that under section 389 clause 1 they can stay on conviction if there is a apprehension that the severe consequences will follow if they will not stay on conviction. But ma'am, in that case they cannot exercise this power in each and every case. They can exercise only rare case in a that was hiding.
Anjali, did they use the phrase rarest of rare?
Ma'am, not rarest, ma'am, rare to rare case. Sorry, ma'am.
Only rare cases, they said. Okay, don't say rarest of rare, because that is a term of art that we use only for death sentence cases, and they did not use that phrase. So we should not attribute tests to the Supreme Court, which they didn't. What is the second main question? No, don't say sorry. I'm just pointing out there's nothing right and wrong. We're all learning together, not a problem. Now, what is the other decision part of the decision? What about direction? Can the legal secretary of the government department issue a direction to the judicial branch telling them that whenever there is a conviction, you must immediately let us know? Was that permissible or not?
Ma'am, in that case, ma'am, once the conviction has been held, there is no, ma'am, can you please repeat the question?
My question was, and if Anjali can answer, other people can also answer. Already when the case was going on, it was noted that the Election Commission has already issued directions to the Chief Secretary telling them that the moment there is a conviction of any MP or MLA on an election petition which had been filed even prior to the person becoming an MP or MLA, immediately let us know so that we can disqualify the person, because that is the verdict in Lily Thomas's case. Lok Prahari had added yet another prayer before the Supreme Court. They asked that the legislative department of every state, in this particular case Uttar Pradesh, should issue a letter to the Registrar General of the High Court, asking the High Court to inform the executive branch whenever a person has been convicted. What did Justice Chandrachud say on that point?
Ma'am, I didn't remember on that point.
You don't remember. Did anybody else read the case carefully? Can you tell me about this point? I'm making the distinction. Already Election Commission had written to Chief Secretary saying the moment there's a conviction, please let us know. Because we have...
I think Justice Chandrachud said that it was not required.
Why did you say it's not required? That is a letter from the Legislative Justice Department to the Registrar General of the High Court. He said it's not required. It should not be done.
Yes, ma'am. Because Chief Secretaries had already been informed. I don't remember it very carefully, ma'am. But I know this much that it was
One
not.
is that, of course, the Election Commission had already written to the Chief Secretary. But is there also any other reason that the court may have said this? Look at it and tell me later on if any of you think so. Okay. Now, Anjali, now tell me, what is the distinction between disqualification that arises? If you have read Consumer Education also, have you read it carefully, Anjali?
Ma'am, I didn't get time because I was reading this.
Fine. Then thank you very much. A nice presentation. I'm now putting my next question, which anybody can
Ma'am,
answer.
I have one observation from this case.
Please make that.
Ma'am, Justice Chandrachud also said that representative people act do not act retrospectively. If a person is disqualified, he is disqualified immediately. After that, he wants to become a member of the house, he has to contest election again and come to the house. So if they do that retrospectively, the floodgate will come that every MLA will go to the appeal and then go. And if the effect of this retrospectively, that will cause so many cases will arise in the court to stay on the conviction and then
Which is why in rare cases will we stay the conviction, right? So staying of conviction is a rare case, and usually the unsaid thing which I would conclude is that it should be done only when somebody has already got elected and would be able and entitled to take the oath of office, but for this conviction. In such a case, you can exercise the discretion depending on the factual circumstance, and in such cases, you can stay a conviction. Okay. Otherwise, normally you will go and appeal, but the conviction will continue. The maximum relief you may have got would have only been the stay on execution of the conviction. Okay. Now, yes, there's also an appeal filed under 374. Yes, who is that Rinku? Yeah.
In this case of Lok Prahari, they have made a comparison between the section 379 and 384 of the CRPC.
No, 374 and 389. You're mixed up. Yeah. Under 374, you can go in appeal. And that special power to stay the conviction is there under 389.
Yes,
and so what in response to, I think that's your question, Rinku, that the court says it is a right to go in appeal under 374. But the relief of staying the conviction should be exercised very rarely by the appellate court under 389 of CRPC.
Ma'am, my question is that they have given the wider interpretation to section 384, but I am not able to get the just.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।